thank y'all so much for being here. I cannot tell you enough how thrilled I am to be in the runoff for Criminal Court 10. All of the hard work really has paid off, and I'm going to go into this runoff 10 times harder. I am a former Harris County prosecutor. I am a current criminal defense attorney. I have dedicated my career to criminal trial law. I have handled thousands of criminal cases as both a prosecutor and a criminal defense attorney. The reason that is important is because Court 10 is a criminal trial court. I am currently, as we speak, in my 35th criminal jury trial. It is a felony murder case. I came straight here from the courthouse. To be a judge in a criminal trial court, you have to be able to rule on motions, on evidence, on objections. And to do that, you have to have an extensive understanding of the rules of evidence, of criminal procedure. These things don't just come overnight. It takes practice. And when I say practice, I mean criminal jury trial practice. I learn something new every time I'm in trial. I hone my skills every single time. The victims and the defendants in these criminal courts, it is not justice for them to be in a court where a judge is learning the rules. I decided to run for this bench because I'm passionate about helping young offenders. Currently, I represent 2 female teenagers. They're set over the age of 17, so they are adults, and they're charged with prostitution. They are victims of human trafficking, and these 2 cases land in a misdemeanor court. So these misdemeanor courts, they are important. I'm working with the DA's office because the DA's office now agrees that they are victims, and we are doing what we can to bring about their affirmative defense. These are the things that I am interested in. I believe I am hands down the most qualified candidate for this race. I am in the courthouse, like I said, every single day. The Criminal Justice Center has been where I've spent my entire career. If you know defense attorneys, if you know Harris County prosecutors, ask them about this case. This bench is important to them. It is important to them that they know who is elected and they know who's going on the bench, understands the law, and understands how to rule. I am confident that if you'll take a look at my website and at my endorsements, if you have any questions, feel free to ask me. Otherwise, please vote Tonya for the 10th.
Good evening. My name is Spjut, and I'm also a candidate for Harris County Criminal Court number 10. This is the first office I've run for, and in the March 4th primary, I'm proud to report I came in first. I had 3 opponents, and I not only came in first, I came in first by a double-digit margin. So I'm quite pleased with the results so far, but I'm not going to slow down in how hard I work to earn this bench. I believe that the Harris County Republicans voted for me because I'm the most qualified and have the most experience of any of the candidates in the race. I was a Houston police officer for over 25 years. I didn't work a desk. For 10 years, I was an undercover narcotics officer. I went into crack houses, I went into heroin houses, I made undercover buys, I got search warrants, and my team executed them. I've seen the destruction that illegal drugs and drug dealers can wreak on our communities and on our children. I've seen it firsthand. When I retired, I was a lieutenant in the gang division. I was the commander of the multi-agency gang task force. Our assignment was to disrupt and dismantle the violent gangs in Houston. So again, I have experience in criminal law from the street. I worked assignments where I was getting search warrants, where I was writing offense reports, where I was testifying in court about criminal law cases my whole career. For the past 15 years, I've had a law license. What kind of judge will I be for you? I'll be one with the good old hardcore Republican work ethic. When I got my undergraduate degree from the University of Houston, I was working night shift narcotics. When I graduated from law school, I was working full-time as a police officer. I'll bring that same work ethic to the bench. I've been a full-time lawyer since 2007. I've tried dozens of cases in the district courts of Harris County. I've had a lot of experience as an attorney. I've handled adoptions, I've handled bench trials, jury trials, mediations. Again, I've been doing it full-time, and I'm a one-man shop. So everything I learned, everything I do, I learned on my own by doing it myself. I feel like I'm very well qualified to be a judge. On a personal level, I'm married. I met my wife when she was a Harris County prosecutor. I was working in the narcotics division. We now have 3 children, 14-year-old twins, a boy and a girl, and an 11-year-old daughter. I ask for your vote. Dan Spjut for Harris County Court, criminal number 10. The Harris County Criminal Court number 10 handles misdemeanor criminal cases. If it's a first-time nonviolent offender, I would look to try to treat the underlying problem. If a defendant comes in there, he's never been in trouble before, he's committed a misdemeanor, and he has a drug problem or a mental health issue, I would like to try to get them treatment for that. But even with the treatment, coming to that court's not going to be a pleasant experience for them, because they're going to have to pay fines, they're going to have to work in the community and do community service as well. So while I will look to treat the problem, I don't want them to think that they're getting a free pass because it is their first offense.
This is actually an interesting question because a pretrial diversion is not given by the judge of a criminal court. Pretrial diversion is an agreement between an offender and the DA's office. As a defense attorney, I put together pretrial diversion packets in misdemeanor courts all the time. I submit it to the DA's office, and the DA's office decides whether my client is deserving of a pretrial diversion packet. The judge never comes into play because there's never a plea. So in that aspect, I am a huge proponent of it. I do it for my own clients. However, it does not have anything to do with the judge in the misdemeanor court. I do believe deferred adjudications and probations are appropriate for a lot of first-time offenders, and I believe that, especially with young offenders, they need a chance to get a second chance and not jump into the cycle of immediately having a criminal conviction on their record. I believe that the misdemeanor courts do not grant enough PR bonds. This has been a huge problem in the misdemeanor courts. There are a lot of first-time nonviolent offenders that plead to cases that they are not guilty of because they cannot afford to bond out, and they have jobs, they have families they have to get home to. So again, that cycle of getting a conviction, they're right back in there. It is up to the judge whether they get granted a pretrial bond. In my court, I would take it case by case, but I don't see a problem in a non-violent case when they're a first-time offender, they're not a flight risk. I absolutely don't see a problem with a PR bond.
For first-time nonviolent offenders, I agree. Our county jails are crowded with violent offenders. We don't need to put first-time nonviolent offenders in there if on a case-by-case basis it's not required. I would rather, again, keep them out of jail while their case is being disposed of, let them keep working, let them keep going to school, and they'll come to the court and get their sentence at the appropriate time without having to sit in the county jail waiting for it. Well, if someone's late, the first time they're late to appear, if it's the first time they've been late or if their first time to come to my court and they're late, I'm not going to revoke their bond if they came in a few minutes late because of the crowded nature of the courts. There's several ways to attack. There's no question that the county criminal misdemeanor dockets are very full. It needs to be addressed. I don't know if maybe we could stagger the dockets. We'd have to talk to the deputies, the Harris County deputies, about would they be able to get the prisoners over at staggered times. But if we could stagger the dockets, have some late morning, early afternoon dockets as well, everybody wouldn't be coming into the courthouse at 9 a.m. Now, that very well may have been tried, but that's something I would like to look at to resolve this issue. But I would not put somebody in jail if they're late because they couldn't get on one of our elevators.
The elevator problem in the criminal courthouse has been a problem for years and years. What I suggest is waiving appearances of some defendants on non-violent cases. These people are showing up every 3 weeks to the courthouse no matter what, whether we're just doing a quick reset. They have to get there, they have to be there for 10 minutes. It's not necessary. A lot of the small surrounding counties, they allow an attorney to be present and they waive appearance. The felony courts, several courts are trying out the staggered dockets, and quite honestly, it's a mess. You show up at 10 and the 9 o'clock docket's still there. I've waited in some of the felony courts for up to 2 hours for a reset, so I'm not for staggering the dockets. Those felony courts are trying. I give them credit for trying it out. But I absolutely believe this is a problem. It has to be addressed, and I do think that waiving some appearances and having less bodies in the building is the answer.
If we're talking first-time offenders, again, possession of marijuana, a minor amount, is a nonviolent offense. I would be okay with that. As a judge, I like flexibility, though. I'd like to be able to judge each case on its own merits and see if it's appropriate in the particular circumstances.
And that's an interesting question, because I will say I have not seen that happen at all in Harris County. I've never come across a case at all.
No one's permitted it.
And so, but it is a unique idea, and it is somewhat similar to even the idea of like waiving some appearances. Possession of marijuana of a very small amount. I don't see a reason, especially if it is a first-time offender, that they're going to get a PR bond anyway. So I would not be against that, and I can't imagine that most of the courts would be against that either. I want to thank y'all so much, and I just want to tell you I am ready day one to be on that bench, to be in front of these lawyers that I know and I respect. These are my colleagues. There is a reason that I overwhelmingly received the most votes in the Houston Bar Association judicial poll. That's where the lawyers voted who is the most well qualified in this race. And that, to me, was one of my most important endorsements, because that came from my colleagues.
Thank you again for having us here tonight. Again, I just want to reiterate that I feel like I'm the most qualified. I think my years of police experience in criminal cases makes me very well qualified to handle criminal law cases. I've been a full-time attorney for the past 7 years. I've held my law license for 15 years. I'm very experienced, and I feel like I have the endorsement of Harris County Republicans because I did come in first. Thank you.